Your Worship, State Calls 20A/113/2023, State against Nandipa Magudumana, Presiding Judicial Officer Mr. Lange, appearing for the State, Mrs. Matoko, the court interpreter Mr. Makala, and the applicant is still legally represented by Advocate Tamini. The matter was adjourned until today for heads of argument or the address by both parties. I must state that when we adjourned, the court pronounced that we will be starting at 11 today. At 11, just before 11, the defense indicated that they're still busy with their papers and requested for 12 o'clock. But we ended up agreeing that we start at 2 o'clock. Just wanted that to be on record. Yes.
Thank you, Mr. Makubu.
Thank you.
Scott, please, Your Worship, I confirm the same submissions made by my learned colleague. Your Worship, we are ready to proceed with the address. And we have also prepared the copy of the heads of arguments for the court. Your Worship, we have also prepared a set of arguments to be given to the state, but I'm not sure if my learned colleague has got a copy for us so that we can exchange the heads. I'm not sure if he has prepared one for us. But we're willing to exchange heads with the state. This copy belongs to the court, Your Worship.
I will provide them at the appropriate time. Yes.
In that way, Your Worship, then we will not be in a position to exchange same if the state is not in a position to provide us with their heads currently. And may I proceed with your leave?
Please.
Scott, please. I will first start by addressing you on the issue of schedule. I remember yesterday when I addressed you, I made an undertaking that I have looked into the charge sheet, I have looked into the charges, and I am convinced that based on what is contained or allegations contained in the charge sheet, that we are appearing before you on a Schedule 5 bail application. But however, after evidence has been tendered, and after I have looked into what is contained in the charge sheet, and after the state case has been closed, I am more than convinced that we are appearing before you with actually a different schedule altogether. But before perhaps I go there, Yoshi, allow me to also make a remark about what I observed yesterday when the state was putting its case on record. The court will remember that the state read its affidavit on record. And the court will also remember that there was a stage when the prosecutor made an amendment on an affidavit. I'm making this submission because that affidavit was not an affidavit which was deposed to by the prosecutor. And in terms of the law, he was not allowed to interfere with an affidavit which was not his affidavit. That affidavit was made by a policeman. It was made under oath. everything and anything that is contained in that affidavit does not come from prosecution. Your Worship, I believe in the experience and expertise of the Honorable Court that the court knows that an affidavit cannot be amended. It is principle of practice that affidavit can only amended through supplementary affidavit by the deponent thereof. But yesterday we had a situation where it was the other way around. So my submission in relation to that is that amounts to a procedural irregularity by the prosecutor. There's only one thing that can be done if there are errors on the affidavit. Spelling errors, those can be raised, those can be narrated to the court to say, at paragraph so and so there is a spelling error. This word, something is missing from this word. Easy as that. But what we saw yesterday, it was a substitution of a word which means something else with a word which means something more different. So I submit that conduct is not provided for in the law. It is not in accordance with the law, and it is therefore unlawful. Then I want to address it on the issue of the legal issue on the issue of schedules. Why we agreed yesterday that it's a Schedule 5, as I said to you, is because we were guided by what is contained in the charge sheet. If your worship looks at the charge sheet before you, there are 16 counts. Out of those 16 counts, what makes this matter to be a Schedule 5, looking into those charges, it's only count number 3 and count number 4. The rest of other counts, they don't turn this whole matter into a Schedule 5, because those are offenses that ordinarily falls under a Schedule 1. The court knows the onus and the standard of proof if a bail applicant is facing a Schedule 5. But I need to persuade you, Your Worship, and to also show you why I am making these submissions, why I'm saying this is a schedule. It's a Schedule 1 and not a Schedule 5. Your Worship, in doing so, I wish to refer you to count number 3. And let's look at what count number 3 states. Count number 3 states that on about 14th of April 2022 in Bloemfontein District, Mangaung, in furtherance of a common purpose, unlawfully and intentionally directly gave or agreed or offered to give to any other person, to wit Tebo or James Dipolo, being accused number 3, any gratification, to wit an offer of 2.5 million, and paid him 40,000 rand. Let's put a full stop there. Your Worship, it was on the basis of the amount which I saw of 2.5 million that I said I can accept that a charge of corruption where the amount is more than 500,000, therefore automatically it will qualify to be a Schedule 5. It was only on that basis. But Your Worship, remember, a charge sheet alone without any support of any evidence whatsoever is not evidence. There must be evidence on record to convince the court that the court is sitting with a Schedule 5 offense. Where is the evidence from the side of the state to show that count number 3 is actually a Schedule 5 offense? Then allow me to refer you to Exhibit J. Exhibit J is the opposing affidavit by the state. Unfortunately, is not numbered. All the pages are not numbered, and I'm therefore unable to direct your attention to a specific page number because all of them are not numbered. But allow me, Your Worship, to refer you to a paragraph which starts with N. Paragraph N. If you count the pages, I think it will be at page number 10. Your Worship. Is Your Worship there? Thank you, Your Worship. It's paragraph N. It's on top of that page, and it reads as follows: that the applicant is facing serious charges. The state has an overwhelming case against the applicant, and this is important, and is linked to the crime as follows. In other words, here the state is saying this is how we are linking the applicant with all these charges as stipulated on this page. And now the state went on to state for count to count as to how the applicant is linked. Let us, Your Worship, on the same page look at count number 3. This is the evidence upon which the state says it is linking the applicant with count number 3. In other words, this is the evidence that the state says, as a result of this evidence, we have an overwhelming case against applicant before you. But let's read what the state is actually saying and what the state is having in order to prove count number 3. The state is saying the applicant and her co-accused acted in furtherance of a common purpose. Their aim was that Bester must escape. The objective evidence of bank statements shows that the applicant was also on occasions a source who provided the money to accused number 1 for distribution to their co-accused. So far, it has been established that applicant paid 85,000 rand to accused number 1. Full stop. This is what the state is saying is overwhelming evidence. And Your Worship, let's focus on count number 3. Let's look who is alleged to be the recipient of the alleged gratification in charge number 3. On the charge sheet, it is alleged to be accused number 3, Tebu James Dipolo. Is alleged to be the alleged recipient of the so-called a gratification. But look at the evidence which the state intends proving the allegations in count number 3. It talks of somebody different altogether. It talks of accused number 1. The charge sheet is in front of you, Your Worship. The name of accused number 1 is not Tebu or James Dipolo. It's somebody different. The charge sheet talks of 40,000 rand, but the evidence talks of 85,000 rand. But let's pause there and look at the law, what the law says with regard to a Schedule 5. There's a Schedule 5 on charges of corruption encapsulate 3 legs. Number 1, it's any offense of corruption referred to in Chapter 2 of the Prevention and Combating of Corrupt Activities Act of 2004. Number 1, involving an amount of more than 500,000 rand. If you look into the evidence which the state says proves count number 3, do we see anything or any allegations with regard to amount of 2.5 million? The answer is a big no. Colonel Flyman, who provided evidence through this affidavit, is silent about an amount of 2.5 million. Is silent. Only the charge sheet speaks about 2.5 million. Where is 2.5 million coming from? Why is the state bringing allegations on a charge sheet which cannot be supported by evidence? Because if you read the affidavit of Colonel Flyman, there's no evidence to support the allegations in the charge sheet. Why are they saying it's a Schedule 5? But let's pause it there and go further and look at other legs of corruption. Secondly, a corruption involving an amount of more than 100,000 will fall under Schedule 5 if it is alleged that the offense was committed by a person, group of persons, a syndicate or any enterprise acting in the execution or furtherance of a common purpose or conspiracy. That is the second leg. It speaks of 100,000 rand. Do we have evidence through the evidence of Colonel Flyman of any figure of 100,000? There's none. But yet the state is saying it's having an overwhelming case. Where is the overwhelming case? The state was actually trying to decorate charges in order to make it difficult for the applicant to be granted bail. It is clear from these charges and from the evidence of Colonel Flyman. It's clear. There's no evidence, number 1, of 2.5 million, number 2, of any amount of 100,000. There is none. But let's look at the third leg of what constitutes a Schedule 5 in cases of corruption. The third leg is if it is alleged that the offense was committed by any law enforcement officer, 1, involving an amount of more than 10,000 rand or a member of a group of persons or whatever. But even there, it does not feature. The question now, Your Worship, is what makes count number 3 to be a Schedule 5? What evidence are we having on record to show that the state has shown that indeed it has got an overwhelming case as it alleges, which proves count number 3, the so-called a count which makes it a Schedule 5? There's nothing. But like I said in my earlier submissions, the state is not only relying on that. It's not only relying on count number 3 to say that the applicant is facing a Schedule 5. It's not only relying on that. It is also relying on count number 4. Your Worship has got privilege of having a charge sheet before you. And I invite you, Your Worship, to look at annexure in relation to count number 4 and tell me if the names of the applicant appears there. There are people who are charged there in relation to count number 4. But the name of the applicant is not there. Applicant before you, Your Worship, is not charged with count number 4. And if you look at the charge sheet, let's look who is charged there in relation to count number 4. You have accused 1, you, comma, accused 3, comma, and accused 7. Applicant before you is accused number 4. Is not charged with count number 4. So the question then Your Worship, is what schedule are we here with? Is there evidence before you upon which you are convinced, or which at least try to put the applicant closer to any of these charges? There's none. Your Worship, if you look into the affidavit of the state, the first 5 pages, it's a very good and nice story about summary of facts. It's a summary of facts. For 5 pages, summary of facts, which does not link the applicant with any offense whatsoever in relation to the counts before you. So I submit, Your Worship, that this is not a Schedule 5, it's a Schedule 1 offense. And therefore the onus of proof is not on the applicant, but it is on the state. But my problem does not only end there with the state, Your Worship. If you look at the charge sheet before you, how many counts are there? 16 counts. Look at Exhibit J, the affidavit of Captain Colonel Flyman. How many counts are accounted for in that affidavit, where they say they have overwhelming evidence? How many? Captain Flyman could only account with regard to evidence to up to count number 11. If you read Exhibit J, where is the evidence that proves count 12, count 13, count 14, count 15, count 16? There's nothing. And yet the state is saying we have overwhelming evidence. I intend, therefore, moving forward to address you, as much as it was not my intention to do so, but because here we have a situation where it is alleged that accused is facing, or in fact applicant is facing, all those charges, which appears to be so serious to the extent that the evidence is overwhelming. But I intend, therefore, to go at least through every of the charges. I don't want to bore you with regard to count 1 and count 2. As we indicated in our affidavit, we will, at an appropriate stage, come up with our defense. We reserved our rights in terms of disclosing our defense. I've already addressed you in relation to count 3 and count 4. I will move to count 5. And in moving to count 5, Your Worship, I will look at what the charge says vis-a-vis the evidence of Colonel Flyman. Count 5 relates to a fraud which is allegedly which took place in the district of Mangaung, where there are allegations that there was common purpose, all those people that are written there. And then you go to evidence of Colonel Flyman on the same page under paragraph N, and look at what evidence he says he's having, which according to him is overwhelming to prove the allegations made by the state to prove count number 5. He says he has got direct evidence or witnesses who confirm that the applicant and the accused 9 claimed the then unidentified body. The objective evidence is that the applicant's fingerprints was on the claim form. Fingerprints on the claim form. In brackets, it is required that the person who claims such a body must give his or her fingerprints. This is the only thing according to the state which they could say that they have in relation to this count. Number 1, they are not saying there was a finger on lifted on a form, which fingerprint we matched with the fingerprint of the applicant and found results which are positive. They are not saying that. Your Worship, you are a court of record. The record before you will reflect. But before I say that, I also need to mention that there was no any identification parade whatsoever that was held, wherein the applicant had to be identified. But why I said you are a court of record, the court will remember, even if Your Worship was not the presiding officer on the second appearance of the applicant, that the court ordered her to expose her face. The court did not do that meromotu, but it did that as a result of the remarks made by the state to say, Your Worship, please order the applicant to remove her mask. And the court did not only stop there, that she must only remove the mask. Even though she had covered her head, she was also ordered to remove everything, to expose her identity. No identification parade held. She says in her affidavit that I do not know any of the witnesses. Now, identities exposed, there are TVs, cameras around there. Now the state comes today and say, no, we have got eyewitnesses. I submit, Your Worship, that if you consider what is written by Colonel Flyman in relation to count number 5, there is no evidence to prove allegations which appears in the charge sheet on count number 5. But we are not there, we're not doing any trial for now. I'm just trying to show, because the state is now arguing that we've got an overwhelming case, which at the end of the day, they're going to argue that they've got a strong case and therefore applicant is not an appropriate candidate to be admitted to bail. I am saying that cannot be the case. I move to count number 6. I'm forced to go this way because there's evidence which the state handed in which accounts for each and every of the charges. And the state further says it has got overwhelming evidence against the applicant. On the basis of that, she must be denied to be admitted to bail. I can't read. Count number 6 is there on record. It will be waste of time for me to read it. But if you look at evidence provided by Colonel in relation to count number 6, it's just a sentence and a half, which he says it is evidence which proves count number 6. In there he also see count 8 to 12. Really, can we say what is written by Colonel in relation to count number 6 proves the allegations or shows that the state has got a strong case in relation to count number 6? It cannot be so. It cannot be so. Colonel is not saying, I have a witness who saw accused number, or in fact the applicant, committing the crime of arson at G4S Correctional Services in Mangaung. He does not say so. Instead, he gives just one sentence where he says it is his evidence that to facilitate the escape of Bester, the unidentified body and Bester's cell were set alight. See also count 8 to 12. This is the evidence. If you read this affidavit which was handed over to you by the state, it is the evidence upon which the state is relying on to say they've got evidence in relation to count number 6. I submit that they have got no evidence. If your worship has got to rely on this affidavit, there's no evidence. I move to count number 7. Count number 7. I look at the charges. Your Worship, as I indicated, with regard to our defense, we reserve our rights to disclose our defense. Can I take instructions? Allow me to move to count number 8. The charge sheet is in front of you, Your Worship. You can see what is contained in charge number 8. It is alleged that the applicant unlawfully and intentionally and in furtherance of a common purpose assisted an inmate Thabo Bester to escape from G4S Correctional Center. These are allegations. Look at the evidence on the affidavit which is intended to prove this allegation. Half a sentence, half a line of a sentence that says, see the contents of evidence, count 7. If you read that, evidence in relation to count number 7 does not even attempt coming closer to these allegations in the charge sheet. Does not. Because if you read count number 7, if you read, in fact, evidence on count number 7, I will read it for the record. It says, there are direct evidence / eyewitnesses that the applicant arranged a fake funeral, that the applicant fraudulently claimed the body, in brackets count 5, as that of Bester. When claiming this body, she also made a false statement to the police. Applicant introduced herself as Dr. Nandipa when she claimed the body of Bester. This, what I've just read, is intended to prove allegations in count number 8. And I submit, Your Worship, that what is contained there has got nothing to do with allegations which are contained in charge count number 8. Those are two different things. if I'm wrong, from this affidavit of Flyman, Colonel Flyman, I will be happy to be directed at anything in this affidavit that proves these charges. I will be happy. Let's go to count number 9. What the state alleges in the charge sheet is not what the policeman comes and states in the affidavit. The state, count number 9, does not charge the applicant before you. But there comes Colonel Flyman with an affidavit, and he says he has got evidence in relation to count number 9. Applicant is not charged. If you read and look at that annexure in relation to count number 9, only accused number 5 is the accused. But let's look into what Colonel is saying, that how he is linking the applicant with count number 9. This is what he said. The applicant rented a house in Sandton, where she and Bester stayed. There is a lease agreement and the files that were seized on these premises after the arrest. The applicant and Bester were seen by members of the public in each other's company. They also committed further fraud after the escape. There was even security to protect them at this house. Is this intended to prove the allegations in count number 9? Can never be. But even besides that, applicant is not charged with regard to count number 9. Count number 10, it becomes a comedy on its own, Your Worship. If one looks into the allegations in the charge sheet, it talks of a commission of a crime which took place in certain areas or places. But what's more important, it talks of a crime that has been committed at Tanzania. She must now be charged here and bail be opposed because of allegations which has got anything and everything to do with Tanzania. It's written here in the charge sheet. I will read it for the record. Count number 10 reads as follows. In that, upon or about 3 May 2022 to April 2023 and at or near Bloemfontein, Johannesburg and Tanzania, unlawfully and intentionally. Can you really charge somebody for? And for that matter, you even bring it in the district court. State alleges that applicant was harboring and concealing an escaped offender, Thabo Bester, in Tanzania. This is what is contained in count number 10. She must be kept in custody, must not be given bail because of allegations that are made with regard to Tanzania. I've never seen a charge like this. Count number 11, Your Worship. Is defeating the ends of justice. I refer you to paragraph O. Paragraph O on the affidavit of the state. There's a terrible contradiction there. It says bail conditions would not prevent applicant to flee the country. Dash, she evaded the police for 11 months. This is the evidence, according to them, that is intended to prove. Count number 11. But to show that what they are alleging here is not true, Your Worship is in possession of a charge sheet. And I invite the attention of Your Worship to a court record before you. Your Worship, there's a charge sheet, there's a J50 warrant of arrest there on the charge sheet. I looked at it this morning. Let's look at what is written there in the warrant of arrest. When was warrant of arrest in relation to the applicant? When was it authorized? The 4th of March 2023, a warrant of arrest was signed by a magistrate in Bloemfontein and a public prosecutor, A. Bester, in Bloemfontein. On the 3rd of April 2023. And the court will see it is cancelled over and it was executed on the 13th of April 2023. This is what is written here. It is part of the record. But let's look at what the applicant is saying in her affidavit. She's honest with you, Your Worship. She tells the court the exact day when she was taken out of the country. She does not hide it away. She said it. It was on the 17th of March. That warrant of arrest, the J50, all that it says before the 17th of March, there was no warrant of arrest against the applicant. Nobody was looking for the applicant. Nobody was tracing for the applicant. And even if you want to ignore that for the moment and look at the affidavit of Flyman, he is not saying, I have gone to so many places looking for the applicant for the past 11 months. He's not saying that. He's not saying that. But all of a sudden, what he is saying is that bail conditions would not prevent applicant to flee the country because she evaded the police for 11 months. How would she know that the police were looking for her if the police did not go to her? She's a qualified medical doctor, well known. It could not be that she was sitting in a place in South Africa which nobody knew where she was. So I submit that this is untrue. It can never be correct. It is also contradicted by the very same evidence which is before the court on record, the J50. And one must ask a question, why? Why is somebody, writing this under oath when he knows that it is not true? Why? What is the purpose? What is the motive? We'll deal with that at a later stage. I'm disturbed by a sound from the prosecution. I don't know if it is meant to ridicule my submissions, but I will request the court to take note of such, because it's unprofessional to do so.
I'm not sure what he's referring to. I'm not sure what he's referring to. Unless you can tell the court what the sound is, I'm not sure what he's talking to.
This record will reflect, he said, as I was addressing Your Worship. It will reflect.
There's lots
I'm
of
still
people.
standing, he must sit down because I sat down when I addressed you. So he must sit down, I'm still standing. He must sit down. He must sit down. Yes. So I'm saying such remarks can never be accepted. This is a court of law. is not a place for such things to be done. We must respect the decorum of this court. And I will request the court to protect me, because if they are allowed, they may be intended for whatever purpose unknown to me, but I'm not going to be distracted by such. If the court wants to still pursue this matter, I can sit down and melancholy can be heard. Thank you.
Indeed, I need to, because there's quite a number of people that are seated on the left side of him. Immediate next to him is Mr. Mutaulu. Then is me. There are two other people behind me. How would one determine where a sound comes from when we have so many people? That is not true. I dispute that I make the sound that he alleged I make, and really, I do not really take this.
Thank you, Oshi.
Thank you.
At this point, I am done with the charges, but I still have to address you with some of the allegations which appears on this affidavit of the state. If you turn the next page to 8.3, now this is where the state is beginning to deal with the real issue in terms of the relevant section 60, subsection 4. In the middle of it, 8.3. I just want to check something. It looks like my affidavit is now upside down. Pardon me, Yoshik, I'm looking for the appropriate one. Oh, I actually wanted Yoshik to take you to 7.1. 7.1. Yoship, you will realize that if you look at this document, it is the very first time that the state now starts to deal with section 60 subsection 4 at 7.1. But even there, when they start, they don't start with section 60 subsection 4A. They start with B. And if you read the entire affidavit, nowhere in the affidavit where they are dealing with section 60 subsection 4A. Nowhere in the affidavit. And section 60 subsection 4A deals with where there is likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense. This is 64A. Nowhere in this affidavit are they dealing with this. So, in other words, I will take this as a concession because it is not being disputed. It is not being denied. They have not testified about it. Nobody said anything about it. So, the only evidence with regard to this aspect comes from the applicant, through the evidence of the applicant in the affidavit. And on that basis, that evidence of the applicant has not been disputed, because the purpose of the affidavit of the state was actually to dispute same, but it has not been disputed. Now I come to B, section 60, subsection 4B, which is at 7.1. Where it says there's the likelihood that the accused, if released on bail, will attempt to evade her trial. If you read this affidavit from 7.1, for the next 5 pages, all those 5 pages, they don't address the requirements of section 60 subsection 4B. They don't. I will tell you, if you look at under 7.1 A, B, C, and D, they talk of obtaining statements from Chun property, estate agent, and they've got nothing to do with the likelihood that the accused be released on bail or will evade trial. There's nothing to do with that. If you turn to the next page, I don't see anything that seems to suggest that it addresses the requirement of section 64B. But of interest is there at the middle of paragraph F, where it says, thus, when providing me with this address on the 14th of April 2023, applicant knew she was no longer staying at this address as the contract expired in January 2023 and had unceremoniously vacated the property on 21 March 2023. Here, Yoshi, on their own version, the state is saying, notwithstanding that the fact that a lease agreement had expired, but applicant was still staying at that particular dwelling. So the fact that whether or not there was lease agreement, according to them, she was still staying there. So what is the effect of a lease agreement? Does it mean because if a lease agreement has expired, therefore that person is no longer staying there? It's not the case. According to them, lease agreement expired, but she was still staying there. That cannot therefore be used as a ground to say that she's a flight risk. 64B is about flight risk. All that is written here is intended to prove that she is a flight risk. And therefore it can never be said that she was misleading, because out of their own version, was still staying there. Lease agreement expired, but was still staying there. And also there is this issue of obtaining affidavits from the Health Professional Council on the 14th of April 2023, and the whole issue of applicant failing to pay the prescribed fees at the Health Professional Council. What does it have to do with a flight risk? Because remember, this is an evidence that the state is saying, on the strength of it, you are a flight risk. It has got nothing to do with that. And unlike the case of the applicant, where the applicant deposed to an affidavit, and in relation to hearsay, despite the fact that hearsay is also admissible in bail proceedings, she went further to obtain confirmatory affidavits. Where are the confirmatory affidavits from the state? Nothing. Captain Colonel Flyman is saying, I obtained an affidavit from Health Professional Council, but it's not even affixed or attached to the affidavit to substantiate the veracity of his allegations. Nothing. There's an allegation that therefore at the time of her arrest she was no longer permitted by law to practice as a medical doctor. What does it have to do with the flight risk? At the bottom of that paragraph, of that page, I established that the medical center is registered with a different address at Townsend Road, Bedford View, Johannesburg. What is the status of a business? Isn't it that a business is also a juristic person in terms of the law? It is written here, Optimum Medical Holdings Group Pty Limited. The law of company law is very clear on that. A company is a juristic person capable in terms of the law of making transactions, acting independently from its directors, and there was nothing wrong with that. In fact, applicant was complying with the law when she registered her company and making use of an address for that particular company, because she was not that company, but the company was a juristic person. Now the state is making an issue about that. And if you turn to the next page, Your Worship, there is paragraph H. It lists about 6 companies. All of them are alleged to be companies of the applicant. They're even saying to some of them, she has resigned as a director. But despite that, they are putting that information on an affidavit. What is it intended to prove? It's intended to show that there are so many addresses, different addresses for each and every company. If you are residing in Bloemfontein, are you not allowed to have a company in Durban and have that company registered or have a registered address in Durban? That is what must be the case. Which is the case, and which was the case even here. And for record, Your Worship, can I take instructions on this? Some of these companies were already dormant. The state considered this to be essential to put it on record in order to persuade the court to say, this is an applicant with various addresses, therefore she's a flight risk because there are so many addresses. It is not the case, I submit. And that this evidence is not relevant for the purpose of this exercise. If you look at paragraph I, the use of a word, elope, by an officer of a high-ranking official of the SAPS, I submit that it is unprofessional, especially if you look into account the context in which that sentence has been framed. All of these are intended to portray the applicant in a very negative way. Why do you use that word? Is it a professional one to be used under these circumstances? I will request the court to have a look at the dictionary meaning of the word. And I submit that it is inappropriate to could have used this word in the context of this sentence. The issue of self-calls being made to legal teams and friends and all, I submit it has got nothing to do with the flight risk. And for that matter, it is incorrect to say that applicant is not keeping in touch with her children. It's a lie. The next page, Yoship, if you look at allegations that are made that applicant fetched accused 5 from KwaZulu-Natal after the escape using this same Porsche, a tracker confirmed the movement. If a tracker confirms the movement of the car, does the tracker confirm who was the driver? What kind of submission or argument is that? I submit that this can never be argued to say it supports the requirement of section 60 subsection 4b. It can never be. The applicant left this Porsche with her security when she fled the country. What evidence do they have that she fled? We placed evidence before this court regarding how the applicant left. The matter was adjourned for more than 2 hours for the state to consider its case. Did they ever rebut that version as to how she left the country? No. Do they have any proof of what they are alleging here of fleeing the country? No. Nowhere in this affidavit you'll ever find that. Paragraph K, it is true that applicant had a passport and it was taken by the police. And we submit that on that basis, she cannot be a flight risk. The issue of the passport being used 23 times for trips outside South Africa. The passport is in possession of the police. Ordinarily should have been at least attached to show proof to that effect. That has not been done. But if you also look at what they are saying, they say he went out of the country 23 times, but he was still coming back to South Africa. What happened to that 11-month they allege in the affidavit, if that was the truth, despite that she was still coming back to South Africa. Now, why do you say she will escape, she will not stand trial? We deny that she was in possession of 2 passports. We deny, and we stated that categorically clear in our papers. But the state says he was in possession of 2 passports. Where is evidence to that effect? And remember, Your Worship, the arrest happened in Tanzania. Where was Captain Colonel Flyman? How does he know about that? If he was relying on evidence from the foreign authority in Tanzania, where is proof to that effect? Nothing. He does not even, as a matter of courtesy, mention a name that according to so and so from somewhere or in Tanzania, this was the situation. He speaks as if he has got personal knowledge of this, and this is not the truth. The unfortunate part of it is that I cannot cross-examine Colonel Flyman on what he's saying, but I submit that this can never be the truth. Your Worship, paragraph L, the applicant has everything to lose by remaining in the country, and there follows number of cases. There are further criminal cases. Okay, there are further criminal cases were registered against her. This include, then the state went on to mention 6 cases. As if not enough, they even decorate those cases with huge amounts of money. First one amount involved 15 million plus minus. It's not the exact amount, plus minus 15 million. The second one, fraud, 500,000. Third one, fraud, 1.2 million. Fourth one, fraud, 5.112 million. And so on and so forth. But what's also important, if you look at the case numbers of these matters, you'll find a case number of April 2023, of February 2023, March 2023. Where were these cases? We are sitting now in tomorrow is the last day of August. Where are these cases? Applicant has never been approached by a single police officer in respect of what is alleged here. Not a single. But let's also look into the law to say, can this actually be, if it is true, be a reason advanced by the state to say applicant has got anything to lose by remaining here because of these cases that are written here. And if you take it further and read the next paragraph, paragraph M, it says the applicant is not only facing long terms of imprisonment if she is convicted on the above mentioned matters, but is also facing further civil claims. The applicant has not been charged, has not been arrested, has not been approached by the police, has not been brought to court. In fact, these cases cannot be regarded as pending cases against the applicant. There's none. There's none. And I'm saying this, I'm seeking reliance on the provisions of Section 60, subsection 11, capital B in bracket, which provides that in bail proceedings, the accused or his or her legal advisor is compelled to inform the court whether Roman Euro number 1, the accused has previously been convicted of any offense. Number 2, there are any charges pending against him or her, and whether he or she has been released on bail in respect of those pending charges. This relates to pending charges. Conditions thereof is that the legal rep or the accused must say, in respect of those pending charges, what is her status? Is she released on bail? Is she in custody? Is she... So with regard to this, they don't even if they can be squeezed to fit in this provision. They cannot fit in. I submit that in terms of the law, these are not pending cases. I'm pushed to come to this submission because of what Colonel Flyman states on paragraph number M, to say that if she is convicted on these cases, as if she is the accused on this matter. She's not an accused. Then I want to move to page a page which has got paragraph 8.3. I don't know what page number is that, but it has got paragraph 8.3, and 8.3 deals with section 60 subsection 4C. Section C, your worship, states that where there is likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. This is what C is all about. But if one looks at the state evidence in relation to C, it's only 2 lines. And I submit that those 2 lines, they don't come anywhere nearer to what is required by 4C. And what is written here is that some of the witnesses are known to the applicant. The counts of corruption are an indication that she could influence witnesses. It is all that Colonel Flyman can say about the state case in relation to the requirement of section 60 subsection 4C. That is all that which he can say. If we move further and look at section 60 subsection 4D on the very same page, there are only 2 points that are made there as evidence of the state upon which they are addressing the requirements of section 60 subsection 4D. And this, Your Worship, it relates to the likelihood that the applicant, if released on bail, will undermine or jeopardize the criminal justice system, including the bail system. And they are saying, A, the applicant, knowing that the information is false, brought a false application for the release of the body. 1. 2, they are saying, the applicant, knowing that it is false alleged in the High Court of Bloemfontein that she was kidnapped from Tanzania. That is all that they could say under section 60 subsection 4D. Nothing else. They don't say anything. These are the only two aspects that they are saying. But now if you look at B, it really does not make sense. The applicant, knowing that it is false alleged in the High Court of Bloemfontein that she was kidnapped from Tanzania, I cannot make head or tail out of that sentence. But this sentence, it is intended to address the requirement of section 60 subsection 40. I don't know how it is going to address it. If you look at A, it makes reference to false application for the release of a body. Does it talk to D? And where is that evidence that state alleges it was brought? Next is section 64E. That there is exceptional circumstances that the public peace or security, a likelihood that the release of applicant will disturb the public order or undermine. And here now the state is saying, the nature of these offenses induced a sense of shock to the community. It was a well-planned operation. Doesn't state by whom. At E, these crimes jeopardize the public confidence in the criminal justice system. The persons who were to ensure that a dangerous person, Bester, was locked up, was put back on the street because of corruption. And then it goes on to say corruption is a huge problem in the country. And basically that was all that they could say. Then they moved to look at the evidence of the applicant. I have a problem with what is contained at paragraph 10.1, where Colonel Flyman says he scrutinized the supplementary statement of 1 Natsai Michelle Chibaya. Where he says he's a Zimbabwean citizen. What is wrong with that? A medical doctor. She's a medical doctor. Coming from our neighboring country, Zimbabwe. What is wrong with that? Who obtained a permanent residence in the Republic of South Africa in July 2018. Nothing wrong with that. It's in terms of the law. But they went further to say her residential address on the system of Department of Home Affairs is whatever address in Johannesburg. Notwithstanding the fact that he was aware that he has now obtained a permanent residence in South Africa, he still wants to create something negative about the doctor. As if there are now various addresses which are being used by by Dr. Chibaya. What is the purpose? She's not in the country illegally. She complied with the law. She's supposed to be in this country. She has got permanent residence. Why refer to address at Home Affairs when she has got her own address? And she's a doctor, an African doctor, but she's referred here that the fact that this person has been staying in this address only from January 2022 is concerning. This person, she's an African doctor. Is it despising her because she comes from Zimbabwe? I don't know. But I feel I have to raise this because it's inappropriate. He knows. He read our affidavit that she's a doctor, but he says this person to a doctor. It's inappropriate and not respectful. And I'm inclined to say it also sounds very xenophobic. And I'm saying this because if you read the other sentence, this is evident that applicant has close ties with Zimbabwe. Her friendship with this person, she states she will stay with, is concerning. I don't know if it's an appropriate way of putting it here. But if I read this affidavit, I am convinced that Colonel Flyman is not a person who is not learned, because in his affidavit, he made reference to State versus Diwani. He's a learned person. But when it comes to the doctor from Zimbabwe, this person. This must not only be viewed in light of what I'm saying, but it must also be viewed in light of the interest of the applicant before this court. Because it is the applicant now who wants to be admitted to bail, who has got a friend from an African country who says, come, I will stay with you. She's referred to as this person. It cannot be right. And under paragraph 10.2, paragraph 7.4, the state is saying, is alleging that applicant was suspended from practice as medical doctor in December 2021, and if she had been practicing as she alleged, this was unlawful. As stated in our papers, Your Worship, applicant had a business. She had a business, and owing to her expertise, if Your Worship looks at the applicant's affidavit, it's contained under paragraph 7.4, which talks of tertiary education and work history. She says, I'm a medical practitioner and a founder of Optimum Medical Aesthetics, a skincare and aesthetic clinic in Centre. And she informs me that what she was doing there, it had nothing to do with the normal practices of a person as carrying out work as a medical doctor, because there she was doing her own kind of work, which falls outside the normal ambit of a medical doctor. I am actually reminded that the record will reflect that out of the co-accused of the applicant, all of them are released on bail except for 2, and there's never been any public disorder of whatever nature. And even today, it is still normal. Nothing is happening. At paragraph 10.3, I have addressed it why that aspect, because it's repeating itself, Your Worship. And other allegations contained there, I will also address them at an appropriate time during trial. And Your Worship will remember that in our papers we also states how applicant left the country, and I see that the state is making a counter allegations to say since the arrest no case was opened of kidnapping. Our submission is that it is an individual's choice and decision to decide on how you deal, on how you forgive, and on how you deal with your past. That will be dealt with at a later stage. And Your Worship, then there is pictures which were attached to the application. If you look at the affidavit of Colonel Flyman, he is making reference to those pictures. The originality of those pictures, nobody is saying anything about. We don't know where they're coming from. We don't know where they were kept before. We don't know who interfered with them. He's not addressing any of those. The authenticity thereof, nothing whatsoever. But they are intended to prove what they are purported to mean. We submit, Your Worship, that the court should not put too much weight on that kind of evidence. The court knows principles governing the admissibility of evidence. And that brings me, Your Worship, to the end of the case for the applicant. for the state, and I was bound to address it in such a way due to what has been alluded to in the affidavit. But I must end by saying the nature of evidence upon which the state relies upon is of a very poor nature, is unsubstantiated, notwithstanding the fact that they make reference to so many people and the fact that they have even obtained their affidavits, but they never even attempted to file just one confirmatory affidavit, nothing whatsoever. But on the other hand, Your Worship, if you look at the affidavit of the applicant and the evidence of the applicant, it is simple and straightforward. She addressed the court about her own personal circumstances, honest with the traveling documents, the family background where she stays. She has got 2 children, nothing was disputed in relation to her rights in terms of the Children's Act. In terms of the assets and the value of the assets, nothing was disputed. And what is the purpose in a bail proceedings of the court considering the assets held by the applicant? It is to ensure that there is value on what the applicant has, which will force her, whatever the circumstances may be, to remain and attend and not evade. But as shown and stipulated, it is clear, I submit, Your Worship, especially with regard to the submissions of the state, that she has been in and out of the country, going out and coming back, notwithstanding the fact that according to the state there was a period of 11 months, but she was still coming back, which actually we don't believe. The criminal history, she has got no pending cases, no previous convictions. And as I stated when I started my address, Your Worship, I have no reasons to believe that this is not a Schedule 1. And I have no reason not to believe that the state case is not as it was portrayed to be, especially taking into account all the factors which I showed through the charge sheet, as well as the supporting evidence. We gave our version, Your Worship, with regard to how the applicant left South Africa. It is contained in paragraph 8 in her affidavit. .1 up to 6.8. The question is, can we point out any evidence from the affidavit of Colonel Flyman which rebuts the version of the applicant? There's no such. Other than what the applicant is telling the court, the state has got no any other version to dispute what the applicant said on her affidavit. Her version remains unchallenged and there is nothing to the contrary. State has not shown that there is a witness or otherwise or any evidence of some kind to show that what the applicant is saying in relation to how she left the country is not true. It has never done that. Is that possible that I can ask just for 5 minutes adjournment? I just want to wrap up my address and
Then Joseph, we state or recalls the matter of Nandipa Magudumana. Thank you.
Worship, I was still busy addressing your worship before we adjourned, and I was actually planning to move to the last leg of my address, which was to address the court on the case laws and wrap up my address. But unfortunately, time is not on our side, and there is some agreement that the matter will then be postponed to a date which I am informed that it has been communicated to your worship. But however, I wish to place it on record that due to my tight schedule, I will not be able to be available on that day, but my learned colleague, my instructing attorney, will finish up where I have ended, and on that basis we are in agreement with regard to the date of postponement. But unfortunately, as I indicated, I will not be around, but my colleague will take it over. Scott, please.
As it pleases the court, your worship, just for completeness, I confirm indeed that we had a discussion with the state with regards to the suitability of the date, and it would have been desirable that the instructed counsel finishes off the arguments, but take into account the urgent character of the bail and the fact that you would not be in a position to proceed further next week. I've been part of the legal team, and I will be in a position to proceed, take over from where he left off, to proceed on the 4th of September. This is the date that has been agreed upon between the defense and the state, as the court pleases.
I so confirm the date of the 4th of September, you see, 2023.
Machini Moto, your worship? Machini Moto Motlawi, yes. Your worship, I need to also place on record that our agreement, the agreement between the defense and the state, is that we need to ensure earnest commencement of the proceedings. We commit to be timeous and to commence at 9 o'clock, so as to expedite the matter and ensure its logical conclusion, hopefully on the 4th of September, as a court basis.
So confirm.
Your worship, there is one aspect that I just wanted to address as well. It's with regards to the directive that the heads had to be finished. Now, owing to the matter having to be adjourned, the applicant's representatives have complied. May I request my learned colleague, without exchanging the heads with the defense, to hand the same to the court as well, as a court basis.
In terms of the processes and the procedure, the state will only be addressing the court once they have concluded, and that is the appropriate time that I will then hand over my written agreement, my written address to the court. The court simply asked us to prepare written heads of arguments. There was no issue about exchanging before them. So as and when I address the court, I will then be submitting my heads of argument to the court. I will do that.
Have you prepared your heads of argument?
Yes, I have prepared them.
I just think it will save time on the next occasion if the defense already has insight into your arguments.
Definitely.
And then they can obviously also just respond to anything that is necessary.
Definitely, that's what I'm saying.
Yeah.
Thank you.
Your Worship, without really engaging in a dialogue, it's just for purposes of clarity, to ensure that we are all on the same page. The arrangement, it would appear, is that the defense will be finished with the heads prior to the next date of appearance, unless I misconstrued the engagement between the court and the state. If that's so, may I then request the state to indicate timelines for submission of those heads to the applicant's legal team as a court basis?
We are really running out of time. I mean, the 4th of September is just around the corner. That is Monday. And we are now at Wednesday. As I said, Advocate Motloko, we would like, I would like you to hand the heads of argument to the defense so that they can have insight into it and be ready on the 4th of September if they have any reply to it. Would you be able to hand it to them today, seeing that you've already prepared it?
Not today.
When will you be able to
Not
do
today.
that?
The court shall have noted that there are issues that unfortunately has now been raised, one of which is very crucial and which is it relates to a schedule. I would not have anticipated that there will be such argument on a schedule after we have agreed, and the defense had indeed agreed that it is a Schedule 5. So whatever I have prepared so far would not have dealt with the issue of schedule of the schedule. Therefore, I need to work on my prepared heads of argument in that respect. And you are not here. You are not here. I'm committing myself to the 1st of September. By 10 o'clock, I shall have ended to Mr. Makro. That's a business.
That's in my worship as a court basis.
But now I have not been finished with anything myself. Will I then also be finished with that by the 2nd of September?
The reply.
No, but they are written heads of argument. I have not been provided with that. So if I can also be at the same time, because they refer to exchange. So I give, he gives.
That's in order, Your Worship.
That's it.
Right, so can I just get clarity? 10 o'clock, or are you saying 10 o'clock in the morning on the 1st?
That's correct. That's correct.
And you will at the same time also just exchange with him your
Indeed so,
heads.
Your Worship.
Thank you very much. Then we have an agreement about the date. which is the 4th of September, and it is for further arguments by the applicant's legal team and then also by the state. And the heads of argument by the state will be exchanged for the heads of the arguments by the defense team on or before the 1st of September at 10 o'clock in the morning. And if there's any reply to it on the same day, please, so that the state can also be prepared when we proceed on the 4th of September. The matter is then postponed until the 4th of September, Ms. Magudumana, in custody, and that is for the purpose of arguments to proceed before this court. Thank you very much.
And that completes our thank you.
I think just for the completeness of the record, the arguments that were handed in by the defense is marked Exhibit K.
As the court, Your Worship.
I'll just do it in my office. Will you bring me both these? Court's adjourned.
Hi.